morning, everyone, and welcome back to the KFAX 14 Morning News. Today for our community conversation, we have two guests with us. We have Brian Stanley, El Paso County's Domestic Relations Office Director, and then we also have Senior Trial Attorney Douglas Knaut. So both of them are here to actually talk about the county's newly passed resolution. That resolution actually fines parents who violate visitation rights to non-custodial parents. Thank you guys so much for being here with us today.
Oh, thank you.
Thank you.
So tell us a little bit about this. What does this entail? What do you want people to know?
So one of the major things to tell, thank you again for inviting us here this morning to speak about the new county order that just passed last week. It's for individuals that have a court order that have been denied access to their child based on one missed visit. This allows us to expedite the process to get to court earlier for their hearing. Typically, in the past, we have our contempt action, which could take, we have 3 missed visits and could take over a year to a year and a half to get to court. And that, based on the age of the child, our office is here to look out for the best interest of the child, make sure that they have access to both parents. Because studies have shown that children that have access and have a positive relationship with both parents tend to have better outcomes.
Yeah, absolutely. And you mentioned that a court order is needed for this.
Yes.
Can you tell us a little bit more about that?
Yes, so you actually have to have a court order to have the possession schedule, either like a divorce decree or paternity order. So the order will list out what the schedule is for each parent to have possession and access to their child. You know, sometimes it's standard possession, first, third, and last weekends of the month, schedules like that, picking up on a Friday at 5 o'clock. And you know, that's where we've encountered where there's been a denial that occurs. And this is to help those parents that have been denied that.
So having a court order, obviously important.
Yes.
I know that, you know, maybe some parents who are not together, they split amicably, have a really great co-parenting relationship.
Yes.
But do you feel like despite that, it may be a good thing to look into getting a court order regardless? Or you feel like if...
Yes, yes. Because usually with your court order, you're going to have your set schedule, because a lot of times parents agree, but then things come up, life happens, things change, and then they don't agree. And so it's a good thing to fall back on when parents don't agree, that they have a schedule that they can fall back on. Mm-hmm. And when they don't agree, sometimes they agree to a schedule that's in their order. Our office also does modifications for when if subsequently things change or they have other concerns. And so, you know, if they have concerns, and so they have maybe safety concerns, our office does modifications as well, so they can get that schedule changed.
And Douglas, you are a senior trial attorney. Can you talk a little bit about maybe the barriers that the county was up against before having an order like this in place?
Well, previously we would file actions for enforcement by contempt. The results of that can be both probation and jail time, as well as requiring more instances of missed visits that you have to prove up before the court. By this county order, we're just looking for one instance of a missed visitation or denial of access, and the relief we're requesting is just a fine, meaning that we don't have incarceration or warrants or compliance hearings necessary, but we're just looking at this one instance in time and the consequence for failure to follow the court order. Our goal is to get everybody following their court orders. We don't want people taking things into their own hands. We want good orders that are enforced and followed by everyone involved.
Absolutely. And let's talk a little bit about those fines. Do they vary? Is there a one-time fine that everyone would receive if they don't follow this properly?
So the fine would be determined by the court.
Okay.
So how it works is you have a parent that's denied, they would fill out an application with our office with a notarized statement. That notarized statement then is part of our pleadings that we file with the court. The other party is served with that, and they both have their day in court. Our office does not provide representation, so our office acts as the gateway to get into the court action to it, so both parties can explain their side as to what had happened. And then the court makes a determination as to what the fine should be.
Yeah, and can you talk about, I guess, the power that you guys really needed to get this up and running? And also, is there Was there a big problem that you noticed, and that was what pushed for the need for an order like this to be put into place?
I think when we received a lot of on our contempt action, we had a lot of issues when we were filing contempt. One, we'd have to have 3 missed visits. It would end up taking maybe a year and a half.
6 months to a year.
To get into court, and then you're looking at the child's age, being very traumatic, being denied their visit to their other parent for a year or 2 years. And then having to serve that parent and that parent not showing up, and then possibly having to issue an arrest warrant for that parent that has the child. And the thought of, what's going to happen to that child if we issue an arrest warrant. This is a much lower level, and it's a fine, and we think that that's a better remedy.
And what would you predict that fine could range between? Anywhere from?
Anywhere from, I guess, $1 to $500. It's up to the court to decide if they're going to charge.
Perfect. And we're talking a lot about court orders here, and you need one.
Yes.
In order for this to work for you. What do parents need to know if they're interested in maybe getting a court order? Who do they have to go to if they are unaware?
So they can go to, if they're looking for a divorce decree, there's the family bar. We have a flick list of family bar attorneys that we provide. If they need establishment, there's also the family bar, but the Attorney General's office does establishment orders. If they don't have an establishment order that establishes paternity, this is the father, this is the mother, this is their schedule. And they set out, the Attorney General can set out a schedule when they're doing the paternity order.
Great information, Brian. Thank you so much. Douglas, anything that you want to add here?
And the DRO also does education services. We're partnered with the law library, so if people want to file on their own, we can provide them templates, copies of forms and resources to file on their own, even if they don't want to go with a private attorney or through the OAG or another office. We also run a monthly pro se workshop to help them ask questions, receive information. We do court-ordered orientation for parties, as well as doing a pro se litigant review process where they can bring us their orders that they've already got in front of the court, and we can go through them and make sure that they are complete and ready to be brought to the judge and turned into final enforceable orders.
Great information. A lot of elements here goes
Yes.
into this, but definitely something that can help families out there who are struggling to follow that routine, that schedule, and make sure that kiddo is seeing both parents if possible.
Yes, ma'am.
Yes, thank you so much. Anything else that you guys would like to add?
The application for all of that is available on our website, epcounty.com/DRO.
Perfect, and we'll actually link that to our website, kfoxtv.com, to help you find that if you would like, and we will also post this community conversation there once again for you to check out for yourself. Thank you guys so much for
thank you,
taking the
ma'am.
time to come into our studio and talk with us about this today.